Good evening, folks. Welcome to the City of Lowell Zoning Board of Appeals public hearing for January 13, 2025. This meeting is held in person at the City Council chambers. Also, you can join by calling in and or through Zoom, through DPD, scheduling ahead of time. Just a few reminders and housekeepings. If you have a cell phone or an electronic device, if you can turn it off or put it on vibrate so it doesn't disrupt the meeting, it'd be appreciated. Also, just a reminder, if you're speaking tonight, if you come to the lectern and you state your name and address for the record. And again, just a reminder, once we open up to the public, people have the opportunity to speak in favor or against a petition. Just come to the lectern, say your name and address, and you have, 3 to 4 minutes to speak. And just a reminder, no yelling or screaming during the meeting. All right, we're moving to continued business. We have ZBA-2024-42. Petition is a variance. The applicant is Suchita Hang, property located at 119 Foster Street. Suchita Hang has applied to Lowell Zoning Board of Appeals to construct an addition at 119 Foster Street. The property is located in traditional neighborhood, single-family TSF zoning district and requires variance approval under Section 5.1 to exceed the maximum allowed floor area FAR and for any other relief required in the Lowell zoning ordinance. We did get communication that the applicant wishes to continue the matter to January 27th. Any comments by my colleagues before we continue the matter? All right, seeing none, can I have a motion to continue the matter to January 27th, please?
To you, Mr. Chairman, regarding ZBA 2024-42 for variance at 119 Foster Street to be continued January 27th.
All right, motion by Mr. Prokop to continue the matter.
Second.
Second by the Vice Chairman. Can we have a roll call, please?
Chairman Peck.
Approve continuance.
Member Callahan.
Approve continuance to January 27th, 2025.
Member Briere. Member Prokop.
Approve continuance to January 27th, 2025.
Member Hovey.
Approve.
All right, the matter's been continued. There'll be no other public notice regarding this petition.
Quickly, Fran, can you, I know those in a butter was represented by counsel. Were they aware that the petition was requesting a continuance, or?
We're not sure, but
Maybe you want to reach out to them.
I will reach
let
out
them know.
and follow up.
It should be, I believe he filed a letter, so he should,
Yeah.
his information should be on the file. So I just want to make sure that they're aware.
Correct.
Yep. Thank you.
I will. No problem.
Thank you, Mr. Ignana. Thank you, Mr. Vice Chairman. All right, moving on to continue business. We have ZBA-2024-59. Petition is a variance. The applicant is Himanshu Patel, property located at 21 Catherine Drive. The Lowell Zoning Board of Appeals will hold a public hearing to all interested persons relative to an application by Himanshu Patel for variance approval to construct a front porch to the existing single-family home at 21 Catherine Drive. The subject property is located in the suburban single-family SS zoning district. The project requires variance approval for Section 5.1 for relief from the floor area ratio FAR requirements and any other required in the Lowell zoning ordinance. Good evening, sir. Welcome back.
Thank you. Himanshu Patel, 21 Catherine Drive. So,
You wanted to tell us about any updates or any new information?
Pending for sign off has been signed off already.
Okay.
And we are just here for the front porch right now.
Okay. And the sign's up and everything?
Everything is
Okay.
yeah.
All right. Do you have anything further you want to share? That's it?
I put the sign that you guys were talking about has been posted. I have the pictures. I sent it to Francisca.
Okay.
The butters were mailed. I had the copy of that too.
Okay,
So
perfect.
everything should be intact.
All right. Thank you, sir. All right. We'll open up the hearing to the public. Anyone wishing to speak in opposition to this petition? In opposition? In opposition? Seeing none, that portion of the public hearing is closed. Anyone wishing to speak in favor of this petition? In favor? In favor? All right. Seeing none, the public hearing is closed. We're going to open questions and comments to the board. The chair recognizes Mr. Hovey. Mr. Hovey, the floor is yours, sir.
Thank you. I drove by, I did see the sign posted. I appreciate that. I do have one question. I had this same question prior. On the site plan, there's two different measurements on the backyard setback. Do we know which setback's the
I
correct?
have the copies.
I have the site plan. Do you have an updated one? Is that the same?
Thank you, Bill.
It's not really. All right, so this site plan has the same issue. I would just have a condition that we get a correct site plan. The backyard setback on this, it says 20 feet, and then it also says it's 25.2 feet.
Okay.
There's two different,
Numbers.
for the same setback from the addition to the backyard. So just if we could get correct measurements on that.
Okay.
I have no problem with the front porch. Again, I appreciate you getting the sign posted, and I have no issues with this, and I'll support it.
Thank you.
Thank you, Ms. Harvey. The chair recognizes Mr. Briere. Mr. Briere, the floor is yours, sir.
No questions, Mr. Chairman.
Thank you, Mr. Briere. Chair recognizes Mr. Prokop. Mr. Prokop, the floor is yours, sir.
Yeah, thank you, Mr. Chairman. I'm also in supporting of it, but as Member Hovey said, I think we should condition this since we just received this, to be added to the site, on the public domain. So this would be, I would agree, the condition. Thank you, Mr. Chairman.
Thank you, Mr. Prokop. Chair recognizes the Vice Chairman, Mr. Callahan. The floor is yours, sir.
Thank you, through you, Mr. Chairman. I agree with my fellow board members and Member Hovey that we need to update the plans because the numbers are not working out. Additionally, you previously indicated on your prior plan that the deck behind the garage was being raised, and it looks like you're putting in a new deck. Is that what's going on, or
But not raised.
it's not raised? Oh, okay. Because, the prior plans had it,
Yeah, but it stayed the same.
it said existing deck to be raised, new deck. So you're not,
We made a new deck, but same. We didn't raise it.
okay, so that the deck's going to stay the same?
Yeah.
Okay. Now, I know, looking at the comments, you got the comments from DPD, correct?
Yes.
And you had a chance to look them over? There was note that they made with regards to your garage, and it being a two-bay garage. As far as there's no existence of what the curb cut is, though, on the existing garage and driveway.
That's gonna come out because we're waiting for the deck to come.
Sorry, can you bring the microphone down and speak
Yep.
into it a little bit? I can't.
That's gonna come out finally because once we do the deck in the front, because there's no space to get there right now. But it's gonna be removed and make a yard.
Okay, but so the existing driveway, what's the curb cut on that right now?
20. This was required by the law.
20? Okay.
Yeah.
Okay, because it's just not, it's not indicated on the,
It's 20.
okay. Sorry, just bear with me one second here. I'm just trying to make sure I got the right. 21 Catherine. Okay.
Okay.
All right. Well, presuming things are in order, I'll take your word for it that nothing's going to change. The only thing's changing is the proposed porch. We get the updated, the deck's not being raised. There's no new deck going on. So is that another addition, another deck addition in the back? Is that what's going back there or no?
No.
So you're putting a deck on, I'm just trying to compare these to the
It's a
prior.
bigger deck on the right-hand side and the smaller deck on the back next to the temple.
The existing deck behind the proposed garage is staying.
That's
That's staying. That's it, right?
Yep.
Okay, because you got another shaded area back here too that kind of looks
Next to
like,
temple, we have a smaller deck there
so
already.
you're putting another deck in the
We already
back.
did it. That's been already done.
Okay, because that wasn't
That's why
included in
new
the
plan
prior.
that has everything in there.
Okay. All right. There's no opposition that has appeared, so I can see myself supporting this with the condition of the updated site plans, providing, the change in the numbers there. Yeah. So, thank you.
Thank you, Mr. Callahan. All right, Mr. Patel, thank you again for coming back, and like my colleague said, thank you for the sign for the public posting. I mean, that's part of the open law requirement, so thank you for doing that. And then I don't see any real issues either. And then the only other thing we talked about is the condition of the updated site plan.
Yep.
So everything, it's agreeable to you?
Yep.
So we'll move forward with a vote. Any other comments by my colleagues before we have a motion? All right, seeing none, can I have a motion, please?
Okay. To you, Mr. Chairman, regarding ZBA 2024-59 for variance at 21 Catherine Drive, variance approval to construct an existing single-family home at 21 Catherine Drive, subject to property is located in the single-family zone. Variance approval per section 5.1 for relief of the FAR requirement and any other required under the laws, with the condition that the updated site plan is submitted to DPD.
All right, motion by Mr. Proko,
Second.
second by Mr. Hovey. Can we have a roll call, please?
Chairman Peck,
Approve the condition.
Member Callahan,
Approve of conditions.
Member Briere, Member Prokop,
Approve with conditions.
Member Hovey.
Approve.
All right, sir, you've been approved.
Thanks a lot, guys.
Wish you the best of luck. Thank you for coming out. Have a good evening. All right, moving on to the next item on the agenda, on the continued business. We have ZBA-2024-62. The petition type is an administrative appeal. The applicant is Mark J. Carabin. Property located at 1280 Middlesex Street. The applicant has applied to the Zoning Board of Appeals, seeking an administrative appeal concerning the Buildings Commissioner's zoning determination regarding the redevelopment and use of the property as a six-family structure at 1280 Middlesex Street. The applicant is seeking an administrative appeal pursuant to Section 11.2.22 of the Lowell zoning ordinance and Mass General Law, Chapter 48, Section 15. Good evening, Counselor.
Thank you, Mr. Harriman. For the record, Attorney Christopher Alphin with Blattman, Bobrowski, Haverty, and Silverstein. First of all, I just want to thank you for issuing that or granting that continuance at the last hearing. I did listen to the hearing, and I noted that the board requested an opinion from legal counsel, and I wasn't sure if the city solicitor was able to chime in on this issue or not. But regardless, I did submit a legal memorandum as part of my application, and I'll stand by that memorandum, but I'll be brief. Our argument is two things. There is basically, we sought administrative appeal to the building commissioner saying that a building permit for a six-family structure should not have been issued because they did not get the requisite zoning relief. Specifically, the use of the structure is not permitted. In this zoning district, 6 units is not permitted by right. It could be used as a pre-existing non-conforming right use if it was grandfathered, but you can lose that grandfathered use if the use is abandoned for 2 years. That's under Section 456 of your zoning ordinance. It's very clear that this structure has not been used for any number of units since 2018. That has been documented in the building department file. There was an issue by the Board of Health that said that nobody can live in this structure. Mr. Carabini, who's also the petitioner of this administrative appeal, was actually the owner of the property. So he knew for a fact that nobody lived in this property. If you don't use the property for 2 years, you lose your grandfathered right. It does not matter if there's actually 6 units and there's 6 units in the structures, you actually have to use it. So if you don't use it, you lose it, and that's what happened here. Now, they can apply for a special permit under your zoning ordinance. There's a section in there under 456 that says if you can revive the grandfathered use, if you apply for a special permit, it meets certain, I think, parking requirements. And certainly the owner of the property could do that. Secondly, so that's the use. And then the second issue is the structure. The structure is a non-conforming structure. It doesn't meet setbacks. And it's also a non-conforming structure because if it's used for the proposed use of a 6-unit structure, then it doesn't meet the lot area. Under your bylaw, you have, or your zoning ordinance, you have something where you say so many square feet depending on the number of units. And with 6 units, this lot doesn't have enough area. So if a lot doesn't have enough area, that automatically makes the structure non-conforming. And as this board knows, anytime you expand or change a non-conforming structure, you have to get a special permit under Section 48, Section 6, but also under one of your sections under the zoning ordinance. And they didn't do that here. I understand that the building commissioner has a difficult job, and I never like appealing building commissioner's determinations. I want to thank Mr. Fuller for being open with us and communicating with us. My client had several questions for him, and he was readily answering those questions, and we appreciate his efforts. He has a very difficult job, but unfortunately, in this case, a building permit should not have been issued. And the fact that it had, under the law, it says that you have 30 days to appeal a building permit, right? If you don't appeal in 30 days, you lose your right. But that's only if you know about the building permit. In this case, it's very clear that the building permit was issued, and then construction started 2-3 months after that. So my client, Mr. Carabini, never had notice of the building permit being issued. Had he had notice of the building permit being issued, he would have a duty to appeal under 30 days. But the courts are very clear that says if you don't have that notice under the 30 days, you can still seek to challenge a building permit by seeking a zoning enforcement. And that's exactly what we did here. We sought zoning enforcement. The building commissioner issued an opinion that says, I have no problem with the building permit that was issued, and then we appealed that, and that's why we're here today. So I'm sure there's questions, and I'm happy to answer those questions.
Okay, thank you, Counselor. So I think we have a few people from the law department here and the building department. From the building department, did you want to say anything at all, Commissioner Fuller? Good evening, Commissioner.
Good evening. David Fuller, Lowell Building Commissioner. I did issue the permit. The abandonment didn't play into my decision. However, I do believe that there is adequate lot area. The scale of the building is larger than it was, but we're not talking about the property. We're talking about the process. And to the best of my understanding, with the plot plan that I was presented, there is adequate off-street parking. The floor area ratio was met. So that's my take on it. I didn't go before the board based on my interpretation of it being a 6-family previously, remaining a 6-family, albeit larger. It came in shortly after COVID and the need for housing. It seemed like the right call, in my opinion, and that's why I went ahead and issued the permit. The law department can get into the legal aspect of it, I would assume, but that is my take on why I issued the permit.
Okay, thank you, Commissioner. If we have folks here from the law department, I don't know, you want to comment from the perspective of the the law department side here, input. Good evening, Mr. Solicitor.
Good evening. Chris Blake, Assistant City Solicitor. So, so in terms of the abandonment, the state law is pretty clear that the zoning ordinance is controlling. The zoning ordinance appears clear as to the 2 years of non-use. We have a vacancy order from 2018. There was a boiler issue at that property. It was deemed vacant at that time, after which we have no evidence of the property ever being used again. It would seem that the extinguishment of the prior non-conforming use would be in effect there. That's our take on that.
Okay, thank you, Mr. Solicitor. All right, we're going to open up questions or comments to the public now. Anyone wishing to speak in opposition to this petition? In opposition? In opposition? All right, seeing none, that portion of the public hearing is closed. Oh, yeah, go ahead, sir.
I actually had owned the property. It's been in my family since I'm sorry, Mark J. Caribbean, 6 Livingston Avenue.
Thank you.
The adjacent
Good evening.
Property. The property had been in my family since 1944 when my grandmother had bought it and opened up a small nursing home. Built 6 Livingston Avenue, I think it was either 54 or 56, I think it was 56 if I'm not mistaken, in which case in 1973, we applied for a permit to put apartments in there because the Pershing rifles from Lowell, or Lowell Tech at the time, after my grandmother had passed away, we had 6 apartments with the ability to go to 8 if we ever decided to, excuse me, to add them. So from 1973, we renovated the building, and I believe they started it right around that time frame. It could have been 76. I was only 9 years old, but and it had been in the family since then. And then the boiler issue, the pipes, the last week of December in 2017, which was probably one of the coldest weeks close to history in Massachusetts, when everybody's pipes froze. New Year's Eve night, the pipes burst, and the fire department and alarms were going off, and water was pouring out into the basement, such, in which case the water department and the city shut the building down due to, you couldn't have habitation there. And it's been, 7 years now. We just finally went to court with Lloyd's of London, who has been dragging it out, causing the abandonment, but it's been abandoned for over 7 years, since New Year's Eve night, 2017. And my parents had passed away in 18 and 22, and my partner and I had bought into the building to fix it up, and then there were some other issues, but there was no habitation, it's been vacant for 7.5 years, or close to it, 7 years, whatever you want to call it, based on that. The original structure, when it was purchased by the new owner, was told he was going to renovate it, fix it up, do what he could to have whatever number of units that originally he tried to get. I believe it was 10 to 12 units in there. I think that was denied. I'm not sure how much other things were done, because then in January of this past, whatever it was, a year ago, I saw a foundation being dug and built. Now my property line is 2.5 feet from the new additions, literally 2.5 feet. And I questioned what was going on, and I called Mr. Fuller, and my cousin, who was one of my attorneys, Brianna Cashin, called to find out what was going on. And I came down to see Mr. Fuller, I believe it was, again, after calling him in January. And he said to me, well, if there's anything going on, we'll stop the project immediately. And I explained to him, I showed him the plot plans, the original plot plans from 1976, where my backyard was, which was granted to the new owner. And I hadn't signed off on that yet until end of March, beginning of April. And by then, the building had been, I don't know, maybe 3/4 put up. Still, again, Mr. Fuller said, we went down on a Tuesday night, my partner and I spoke to him in person around 6:30, 20 or 7, gave him all the details, and I was told by Mr. Fuller, if he remembers, the more they build, the better your case will be. Quote, unquote, verbatim. And I have a witness here that he spoke to that knows him better than I do. But I just wanted, I tried to find out what was going on legally. I tried to go the right routes, and that's what I was told. And so now, after all that, I had to try to find a land attorney to find out what was going on, and I'd been trying to deal with the city based on that. And that's what I was told by the commissioner's office and the commissioner himself. And I know I've had family that worked at City Hall close to 80 years ago. In fact, one of my uncles was a building commissioner here. And, you know, I've been in Lowell my whole life. My family has been here since the 1880s. Not that that's relevant to anything. I didn't really want to originally come down to City Hall and go through this, but I just feel that the whole story needed to be heard. So, you know, but it's literally 2.5 feet from my property line, and there's no real off-street parking. So I don't know where the off-street parking is, because you really can't park on Middlesex Street like that in front of the building. So that doesn't make any sense of that being said before this board. And Livingston Ave has all kinds of new neighborhood parking, whatever you call it, that was put in there a few months ago. But anyway, I just wanted to express that few items, and the board can go from there, I guess. Thank you very much for hearing.
Thank you for your comments, sir. Anyone else wishing to speak in opposition to this?
Actually,
Good.
Mr. Chairman, I think it point of parliamentary procedure, because this is an unusual, sorry, just bear with me.
No, go ahead.
This is an unusual situation. We haven't done an administrative appeal in quite some time. Fran, would it be easier if we just open it up to the public in general as far as opposition and for and opposition? Because I think that may confuse the lines of who's planning to speak for what, and just let the general public speak that piece. I think that would make more sense, Mr. Chairman.
Yeah.
Instead of in opposition and in favor, just having members of the public speak in general.
Yes, that's, I think, just because
That's fine.
it's kind of blurring the lines a little bit, because the petitioner is the appellant.
Yeah.
The city, the commissioner of the city is the appellee.
Yep.
If we were in a court, if we were in a court of, and just for the, you know, for the record, for people know I am a lawyer, so I kind of understand the procedure a little bit, but I think for the general public, it may confuse the lines of what they're getting up to speak for or against. So I think just in general, just instead of calling it.
That makes sense. Yep.
I think as long as everyone who would like to speak has an opportunity to speak, that's the important thing.
Yep. Okay, makes sense. Thank you, Mr. Vice Chairman. Good evening, sir. You want to state your name and address?
Yep.
And share with us.
My name is Bill Mantville. I am the current owner of 1280 Middlesex with my wife, Deborah.
Okay.
There is a little bit of misinformation going on, in my opinion. First of all, I'd like to say one thing. As an investor, as a person of investing into this property, we've done nothing but stay exactly what the building commissioner has asked for, plus some. We've basically spent another 20% more to make sure everything is right and conforming. Brian Occasion was my lawyer. We have full documentation on it. Peter Nicosi was our lawyer. We went full legal on exactly what we could do. Brian from Swindle City surveyed the problem multiple times. We have multiple information on that you, obviously the commissioner hasn't also. I just want to say a couple of things that is going on here. You know, I haven't gone to last meetings. I understand that Mr. Caribbean, original owner of the property, you know, had some issues with the land. And the misinformation is the fact that Mr. Caribbean didn't realize what was going on with the property. It's incorrect. I was in full contact with him verbally. We have spoken about the project. Matter of fact, I took this house, no offense, from a abandoned property crack house out of a bankruptcy court, helping Mr. Caribbean, in my opinion, my family. Again, that's just something that we felt it would do, because I was contacting Mr. Caribbean to buy the property from him to help him, because, you know, as far as I'm concerned, his mother and his family, wonderful people. I have no problem with that. It's not a personal issue at this point. The fact of the matter is that this particular project in this house We're not the type of people this is not a first rodeo. We're not to go around the building commissioner, the zoning board, or anything of that. We've taken this building enough. You've seen 1280 Middlesex Street, but we've increased the value around the property. Most of the neighbors, at least another 50,000. This particular property was 6 units in there, and I walked through the property. Was there water damage? There was a lot more than water damage in this building. This building also had squatters in it. I mean, even when we purchased the property out of bankruptcy took obviously about a year for that. There was a lot of issues that went on with the building. My wife and I, we basically were very much, involved with community. We donated a building to the Lowell Fire Department. Myself being a firefighter too, I wanted to make sure the training was proper, and I want them to know the building in case of an emergency. Obviously, understanding some buildings in town have been dangerous. I'm very, very much, proud about what we did there. And again, as an investor and as a person of helping Mr. Caribbean and giving us the opportunity to build building, we have been very upfront about everything, step by step. Again, Mr. Fuller, building commissioner, I'll be straight with you. To invest in this city of Lowell, I'd be more than happy to do business, gentlemen. He has been nothing but upfront. We have been upfront. And also, the one thing that I really see is coming back to the city to invest. Clearly, the city would have investment in housing, and it was during COVID. We took a risk, and the building at the time was like, okay, it's 6 units. We thought we'd like to do 10 or 12 units because we wanted to open up possibly to some low-income housing, but we were denied that. I said, no, we can only do the 6 units due to grandfather, that particular situation. There were people in and out of the building, by the way. I had plenty of pictures on that, so I don't know, living or squatters, whatever it was. But one of the major things for me was when we got into this, like, oh boy, we got a bigger project than we realized. But as far as the building expansion, we have 12 spots. I also have my architect that worked on that. All the plans were completely straight out. I explained to Mr. Carabine also that what we were doing there was nothing hidden. We also, all the land, when we purchased the building out of bankruptcy, there was a small parcel of land that went with the building in the purchase and sale. And I also, just so you understand, that 1280 Middlesex Street and 6 Livingston Street were a joint property. I purchased the property at 1280 Middlesex Street, and I gave and paid all the bills off of 6 Livingston. Please understand this. We divided property because I did not want to see Mr. Caribbean homeless or his family, because I felt very respectful about that to him and his parents. I felt what was needed was increase this building, make it look beautiful so that the values of all the property and the neighborhood brings it up a level. I'm no stranger to Lowell. My wife's family's from Lowell. I have also a seafood company. I've delivered to Lowell for a lot of times, La Beniche, Ricardo's. I'm not a stranger to the city. I love working in the city. I've been to the city on fire calls to back this up as mutual aid. And what I'm saying to you is, my frustration point right now is we're trying to get buildings like this out of squalor. Things that were basically a deadly hazard to a fire or police. And that's what we have done. And we've done it all legally. And the whole point, too, is the support of the board and the support of the commissioner would make us come back to this city and say, let's develop the other property across the street or the one down the street. So I just want to make clear, I'm always open. You're welcome to call me at any time and come see the building, see exactly what's going on down there. But it is nothing but perfection and done to exactly the commissioner what he asked. We did plus some. It's under a HERS program. It's all electric. It's going to be all conforming that way. And like I said, it's been a pleasure to work in the city, but I just want to get to the point where I be neighborly. You know what I mean? That's a part of it. It's community. And so, the neighbor next to Mr. Caribbean, he's a neighbor, and we want to make sure that everything is going to be up and up. We have been through the process of this building also harassed multiple times. My building was torched at one time. It was almost lit on fire, and we worked with that too. And the police department and Eddie Lodi of the fire department have been phenomenal trying to figure out who tried burning the building down. So we've gone through a lot ourselves. Granted, I understand that Mr. Caribbean says that, the land, everything, but it's not true. We have actually done everything exactly to what the city, the commissioner, and our lawyers and the surveyor has asked. And we've had all that surveyed. And we also submitted all that before we did that. So again, I have no problem, questions if you have, or to come to the property, I'd be more than happy to give you a tour. Thank you, I appreciate it.
Okay, thank you for your comments, sir. All right, we're still in the public hearing section of this hearing. Anyone else wishing to speak on behalf of this petition?
Chairman,
I just want to open up to the public, and then we'll go back to you, okay, Counselor? And anyone else from the public want to speak on this petition currently? Any members of the public? All right, going once, Going twice. All right. All right, the public hearing is closed for right now, but if we have comments or questions, we'll go back to it. Now we'll go back to the applicant. Go ahead, Counselor.
I just want to make sure that the board doesn't get distracted of what my client was saying and what the developer was saying, which was whether this is a good project or not. That's not what we're here to do. I mean, the developer might be absolutely correct that these are projects that Lowell needs, and as somebody who represents developers on a nightly basis, I can totally understand that point. The point is that we need to apply the zoning ordinance, and we think that the zoning ordinance was clearly broken, and I know a building permit was issued, and that's unfortunate, but at the end of the day, the zoning ordinance needs to be upheld. If the board isn't happy with the zoning ordinance, then, you know, they can certainly change it. And we're not necessarily saying that the project can't happen. We're just saying that he needs to go through the necessary steps, which in this case is going to be maybe a few special permits. And we just want to make sure that conditions are included in a project this big with this much impact of 6 units in a small neighborhood. Thank you.
Okay. Thank you, Counselor. All right. So we're closing the public hearing for right now. I'm going to open questions and comments from my colleagues in the board. And then for my colleagues, if you have specific questions or comments for anyone, whether that's the applicant or the city or the building department or anyone, just feel free to ask away. Okay, folks. All right. The chair recognizes Mr. Breer. Mr. Breer, the floor is yours, sir.
Thank you, Mr. Chairman. My question's for Attorney Alpern. What is the remedy that your client is seeking?
So what we're seeking is for you to overturn the building commissioner's determination, and then in that case would be overturning the building permit. And you could make a decision that says, you know, after the fact, he can come and get special permits. You know, at this point in time, just because the way these things work, I'm not telling them to tear down the building. I'm telling them to go through the proper channels. So what this would be overturning the building commissioner's determination, which would overturn the building permit, and then require him to go get the necessary zoning relief. So that's what I'm seeking. Does that make sense?
No.
Okay.
What relief does that provide you?
Well, it provides him with having the zoning board make a determination, apply the special permit criteria, if that's what's required.
No, I get that.
Yeah.
I get that. To our attorneys, one of the city solicitors, could you come to the podium, please? So is this within our purview?
In terms of making a determination as to the appeal itself, in terms of...
But to do that, we're being asked to override the building commissioner?
So when it's a zoning...
Overrule him?
Yes, that's what a zoning enforcement appeal would be, is to go against the prior determination as to the zoning enforcement request, which would in turn extinguish the previous permit.
So it's your opinion that some violation occurred?
Based upon the opinion, it does appear that the property was abandoned at the time.
Okay, so was there a violation?
If the property is not...
I think the property is absolutely beautiful. And I think if the developer's goal was to enhance the neighborhood, he did that with flying colors. We need that property. I didn't understand some of the other comments about parking. There's a beautiful parking lot right there. I mean, what they did with that property, my God, who wouldn't want to live next door to that? Who wouldn't want to live next door to a property like that? I guess what I'm getting at is you're making us be like dogs chasing our tail. So we tear up this, and then you come back before us, and then we say, okay, it's already there. You don't want it tore down, so what do you want us to do? I want it to stay there. Can't we come to some agreement to just let it stay there and be done with it?
That's not the question before the board.
All right,
The question for the board in this hearing, and this administrative appeal, is was there a zoning violation?
Okay.
And if there is, then maybe there's a second question later on. But we need everybody to follow the zoning ordinance, and that's the job of the ZBA.
All right, well, the attorney said that there was a violation, so what's the next question you said? That
So the decision would be to overturn the building commissioner's determination. They would essentially, we'd be asking them to revoke the building permit and offer a cease and desist. And if they want to continue building, they can come in here and seek the correct zoning relief. Look, that's the ordinance.
All right, back to the city solicitor. When we asked for a legal opinion, it was my understanding that we were asking for guidance on how we proceed with this. So if there's a violation of law, are our hands tied or not?
I mean, it's in the board's purview to act.
Well, no, I want you to tell me. You're the legal expert. I'm just playing one on TV right now.
Well, I mean, it's not our job to make a ruling.
No, I don't want you to make a ruling. I'll be more than happy to do that.
Okay.
Tell me what we can do and what we can't do.
You can vote yes or no as to this appeal. If it's a yes, that zoning enforcement would be taken back. The letter from Commissioner Fuller previously describing why he issued the permit would be null and void, and that permit would technically be null and void in that situation.
All right. I mean, you already know how I feel about the building. I'm in love with the building. I don't want it to go anywhere. I'm sorry that all this happened. But are we setting precedent here now? Is somebody just going to go out there and do, tell me what to do.
My hands are tied when you say, tell me what to do, but
I don't want to violate the laws. I guess that's what I'm getting at.
So the ordinance it's straightforward. It appears in saying it's 2 years as non-use. What we have is the evidence that we gotten, and nothing there would show that it was used in those 2 years. Based on that, that's how I viewed that ordinance, in that it would be abandoned at that time.
All right. I don't see how you're losing anything. If there were damages here that you could receive or something, I'd say, okay, we gotta put a, but you're gonna tell us to say no, rip everything up, right? I'm talking to Attorney Alper now. Rip everything up, just for the sake of ripping it up, and then we're gonna come back here and we're gonna say okay, and the building's gonna stay there.
This is
Isn't it a waste of time?
not just, and just to be clear, this is not just on the abandonment. This is a pre-existing non-conforming structure. And this is a major modification to that pre-existing non-conforming structure. That is a big addition. If there was an opportunity for Mr. Carabini to come in during a special hearing process that was what should have happened, maybe it wouldn't have been as big, because the neighbors would have had an opportunity to say, this is going to be a detriment to the neighborhood. This is going to be a huge building next to a small house. There's not enough screening, et cetera, et cetera. That opportunity never happened. So we're trying to correct an injustice that happened here. And I understand the point. I mean, I know that the building's already there, but that doesn't change things.
Okay, I think someone.
You have to uphold the zoning ordinance. There's no way around it.
Yeah, that's what I was asking our legal counsel to advise me on. If by allowing this to just continue as is, are we violating law?
We'd be in violation of the ordinance.
I'll let my next colleague speak, Mr. Chairman. Thank you.
Thank you, Mr. Brier. All right, the chair recognizes Mr. Prokop. Mr. Prokop, the floor is yours, sir.
Thank you, Mr. Chairman. Yeah. Well, this is a first for me, so. Mr. Solicitor, so you just said that we would be in violation of the law if we upheld it, right? If we upheld.
Upheld the appeal itself?
Yes.
Or denied the appeal?
If we don't deny the appeal, I'm sorry, if we deny the appeal to revoke Mr. Fuller's determination, we'd be in violation of the law.
I would say that based on the ordinance that does rule it as an abandoned property, at that point, it has to revert back. It would be a situation where if we're making a ruling as to whether or not there is an abandonment on the property, the ordinance is clear.
Okay. So, and if we revert back, then, I'm sorry, I forgot your name, Attorney.
Attorney Alpin, yeah.
Alpin, that the applicant should apply for special permits. And if they apply for the special permits, we're not talking about breaking down the building, but it sounds like
Yeah, I mean, I'm being practical here, right? I mean, legally, what I'm asking them to do is revoke the building permit and technically say that the building itself is a zoning violation and that it should be fined and potentially torn down. But I'm a land use attorney. I know how these things work. And that is probably what should happen, is that you give the developer an opportunity to apply for the zoning relief required. So, and in practicality, that's what's going to happen. But what your decision is doing is essentially revoking the building permit.
Okay.
What they do after that is up to them.
But in this case, what you're saying is that the butters, they're not happy with the building in the first place, aside from the fact that.
Yeah, and, again, that is a conversation we can have during a special permit hearing. But for this purpose, for this hearing, it's whether there's a zoning violation or not. What happens afterwards, of whether they meet their criteria for the zoning relief, that will be the next question, but that's not what's before the board right now.
Well, since this being an administrative appeal, I think everything is in front of the board at this point, because
I think before the board is whether there's a violation or not. Whether the building commissioner was incorrect in issuing a building permit is the only question before the board. And I think that that's clear, because there was an abandonment and an expansion of a pre-existing non-conforming structure. That's a violation of two different sections of the zoning ordinance.
Well, I agree with Member Beer that it's a beautiful building. I've driven by several times, and I think it would enhance the neighborhood. But I guess we, from a zoning standpoint, we do adhere to, what the ordinances are. But the Zoning Board of Appeals is also for exceptions and exceptional purposes. So I will listen to my fellow board members before I render any decision.
Okay, thank you.
Just a point there, because I think Mr. Fuller mentioned that, an exception should apply here or not. That's not what's before the board. This is not a variance decision or special permit decision by the board tonight. This is there a violation? Were they allowed this permit by right? That's the question before the board.
Okay. You all set, Mr. Prokop? Okay, thank you, Mr. Prokop. All right, Chair recognizes the Vice Chair, Mr. Callahan. The floor is yours, sir.
Thank you, through you, Mr. Chairman. So, Attorney Alpin, you stated previously in your initial presentation that Mr. Karabian had no notice of the building permit.
Correct.
When did he find out about it?
When the construction started around in February, and we see that the building permit was issued in December, so that was more than 30 days. And so the law is I don't necessarily agree with the law here, but it basically says if you don't have notice, and that could be constructive or actual notice of a building permit, then you don't have an obligation to appeal within 30 days, and then it's sort of wide open from there.
I would agree. I mean, well, as I prefaced before, I am an attorney. I don't practice. Land use is not my regular form of practice. This is more of a side gig, I guess you would call it. But I am familiar. I mean, I am familiar with
Calvin versus Wellesley. Yep.
I'm familiar with the statutory law. I'm familiar with the case law. And the case law, and I think you know where I'm going with this. Case law is pretty clear that I understand the process you're using with regards to the determination, but my understanding is the SJC has found that that's only in very extreme circumstances, because the notice has to be really no notice. They talk constructive. You mentioned constructive notice counts.
Right. And so a lot of the case law where the person doesn't have constructive or actual notice is when the building permit is issued and then they don't do anything for more than 30 days. So how would they have noticed that something was going on? And that's what happened in this circumstances. And that's what a lot of the case law on that issue is that, the case law says basically, a developer could get away with the 30-day by just getting the building permit, not doing anything for 30 days, and then they're scot-free.
Okay.
That burden is actually on the town, believe it or not, to prove that they actually had notice within that 30 days.
Okay.
I don't see any evidence that says they did.
Let's try to clarify that. Commissioner Fuller, can I ask you a quick question, please? I note in your response when the request for determination was made by Attorney Alprin, Alphin, excuse me, my apologies. You made a statement right at the end. Mr. Caribbean and John Faneros, potential investor, came to my office after construction began to contest the project. Do you know when that happened?
That was in the winter of, I want to say, 22.
Okay.
I'm not certain on the year, 22 or 23. But I do know that the permit was issued the year prior, and that they were doing foundation work the year prior to Mr. Caribbean and Mr. Faneras coming into my office.
Okay, so just so we're clear, permit was issued in 2021?
If that's, I'm
Oh,
sorry.
you
I'm
said year prior, so.
Yeah.
And then permit was issued, construction began, and then you say that you met with Mr. Caribbean and Mr. Faneros sometime after that, sometime in
Correct.
2022?
Yep.
Okay, thank you.
You're welcome.
I think that makes it clear for me, counsel. This wasn't filed until November of 2024. I believe I understand what you're trying to do, but I believe this case law is clear. And actually, if the law department wants to kick in on this and confirm for me that I'm correct on this,
Well-
or unless, counsel, if you want to
No,
tell me
what-
where I'm wrong.
No, so he just said that the building permit was issued November of 21.
Yep.
And they met, I think, in February or January. That's more than 30 days. So
Okay.
they have to have constructive notice within 30 days of that building permit being issued. So you would have to show that from November, whenever the building permit was issued, that they had actual or constructive notice. No.
Okay.
It's not quite.
Cut.
Everybody stop. Okay, so right now, excuse me,
Let
Mr. Vice Chairman.
me go over another.
So the Vice Chairman has the floor. This is not a debate back and forth. He has the floor. If he has only comments, no one can answer. If he has specific questions to anyone, yeah, then people can answer. But unless he has a specific question to you, please do not answer or yell out. Sorry, go ahead, Mr. Vice
Okay, no
Chairman.
problems. So when did construction actually start?
We believe that construction started in sometime in February of, let me make sure I have the right, you're right, 24.
So permit was issued in 22 and construction didn't
No,
start until
no.
24?
Permit was issued November 27, 23,
Okay. Permit was issued in 23, construction didn't start till 24?
correct. November 23, construction started in 24. According to my client, there might be, he didn't write down when it started, and we're happy to hear records of what they have. But I'll add this. There has to be actual constructive or actual notice that they were going to make a huge expansion, and they were going to keep that as 6 units. And so they may have started doing some tear down. That's not necessarily enough to create notice, but.
Well, what's troubling me is even if construction started in 24, you didn't file the appeal until November of 24.
No, but so what?
Even regardless of whether it was under Section 8 or Section 7.
No, okay, so
You know,
this
regardless of which way you're
I don't
doing
agree
it.
with the case law,
Yeah.
but this is what it is. If you don't have notice within that 30 days, okay, so you prove that you don't have notice, then you can seek zoning enforcement by seeking enforcement by the building commissioner.
Understandable.
You're not cut out. So what happened is, he didn't have notice. We filed a zoning enforcement request. The building commissioner gave an answer, and we appealed that timely. So jurisdictionally, we're okay with that. Unless there's evidence that we had notice within 30 days.
Well, You say
Of
we're
the
okay.
building permit being issued.
I don't want to disagree. You say we're okay. I don't say we're okay. I don't think the board has jurisdiction in this. I think, unfortunately, you're outside the time limits. The board does not, I don't believe the board has jurisdiction under that, under those confines. I don't think we can make a ruling because of that jurisdiction, and I will be denying the petition. So that's my opinion.
I issued a legal memorandum.
Yep.
I'm not sure if the board has that on this particular issue.
Sir, that was just a comment he made.
That's okay, you can speak. I mean,
Okay.
go
Well, I
ahead.
just want to make sure I did, because the city solicitor called me and said, hey, this is, what about the 30-day? And I said, oh, you don't think I thought about that? That's the first thing I.
No, I'm not saying you didn't. No,
Yeah, I
of
know.
course not.
So it's something that
You-
we reviewed, and I just want to make sure that the board had a copy of my.
We do,
memorandum.
we do.
Okay.
We do.
Dated,
But,
it's dated November 22nd. I just want to make sure that's part of the
Yeah.
record. Because I sent it to the city solicitor's office. I didn't necessarily.
I could, my point is, I mean, I have my say on this thing.
Yep.
I do have a different perspective than my other fellow board members, obviously with my, profession, and just letting them know what my opinion is. Thank you.
Okay, thank you, Mr. Callahan. Before I move on to my last colleague for comments and questions, just again to the public or anyone here, if a board member doesn't have any specific questions to you, you cannot answer. Again, this is just the board's time to speak, so please do not speak out or say anything unless a board member specifically asks a question to a specific person. So, sorry about that. Mr. Harvey, the floor is yours, sir. Go ahead.
Thank you. Attorney Blake, could I ask you a question, please? Is it your opinion that we have jurisdiction over this, or?
So, this is a twofold question, right? When we're dealing with the issue of constructive notice, it's my view that that is even a question of state-specific law. We're looking at inside of a statute. Now, at that point, there is an option for the board to rule they don't have jurisdiction over that on that aspect. If the board is to rule that this is not timely, there would not be jurisdiction either. That would be the first step in making a determination on this appeal, is whether or not it's timely, and then the merits would be decided.
And there would have to be some type of attached documentation, because right now we're just getting, I don't want to say he said, right? I haven't seen anything about, we notified abutters, we've done any documentation of that. Quite frankly, I heard different dates bandied about here, so I don't know how we can make a determination if we're not technically in the right year.
Yep.
It's kind of concerning that we're going to say, we don't have jurisdiction when our dates are off on this by a lot. So if there's no documentation, what do we kind of determine that on?
So the difficulty obviously there is when, if we're talking about constructive notice, when would that individual have noticed it? Those typically come up in cases where the permit's been issued, right? And at that point, they look at outside and they see construction that would satisfy notice if construction's began. I don't have a specific date as to construction starting, unsure as to that. But if that was within 30 days of that building permit and Mr. Caribbean could look outside, technically that would be considered constructive notice on those situations.
Right, but we don't have any evidence of groundbreaking or anything.
Exactly.
Thank you. I think Commissioner Fuller probably said the most sensible thing when he got up there and he said, this isn't about the property, it's about the process. And, as the city solicitors have said, that there's obviously been an error somewhere with the process. I'll keep my opinions on the property to myself, because that's really not what we're talking about here. We're talking about, was the correct process followed? Unfortunately, at this point, I don't think it was. I don't advocate for tearing down a building, but we do have a process to go through zoning. That's why we have ordinances. That's why we follow the rules. Special permits, variances, the site plans we have on file, this would need 12 parking spots. It doesn't have parking. There might be a site plan that does have parking. It's not in front of us, so I don't, you know, could it be a perfect project? Absolutely. Do we have the information? No, we don't. I think we lack a lot of information here, but the only information we have is the property wasn't used for over 2 years. That negates the nonconformity, and in order to reestablish it, you'd have to go through special permits and variances. So that's the way I'm going to lean, just process-wise. And if it does come before us, or you know, it goes a different way here, you know, I would like to see this done properly. That's all.
Okay. Okay, thank you, Ms. Avi. All right, I only have comments. I don't have any questions for anybody. Again, thank you for all the speakers tonight, the applicant, the appellant, the city solicitor, building commissioner, the owner of the property. Thank you all for coming out tonight. You know, we don't get a lot of these administrative appeals. In my opinion, I think the city and the building commissioner was in the scope of issuing the building permit. You know, there's some logistic stuff that I think we need to hash out, but again, I am voting not to. I'm voting to deny this. I really think it's in the scope of the building's commissioner's rights and authority to give out this building permit. All right, any question from my colleagues before we move forward? Ms. Callan, go ahead.
I guess point of parliamentary procedure again, and I don't know if the law department can weigh in on this. Should we take a vote first, initial vote to determine whether or not we have jurisdiction at all based on the timeliness, and then if passes, then go towards the merits? Would that be the?
My comment, I agree with that.
That was going to be my. Does the law department have anything?
Yeah, I'm okay with that. Mr. City, do you have a please comment on that?
Just to get some clarity, you want to make a vote as to whether or not it's timely and then move forward with
Make an initial vote as to the timeliness and whether we have jurisdiction to hear the appeal, and if that fails, so be it. Or if it passes, then we move on to the merit. We move on to a vote on the merits.
Okay, yes.
Is that's agreeable to both parties?
Yeah, I think that legally that's the way it actually should be.
Okay, thank you.
Thank you, Mr. Vice Chairman. Mr. Prokop, did you get that?
Do we have any documentation on the timeliness of this? Again, we just heard multiple different years that this project took place over. And I can tell you for a fact,
it would be based on what we heard right in front of us. If you don't believe that we have, and I'm not going to sway you either way, Member Harvey, but if you don't believe that we have information regarding the timeliness, and if you think it's timely, you can vote yes that it's timely, and then we just move on to a hearing, a vote on the merits of the appeal itself. That's what I'm proposing. I don't know, counsel. What do you?
I just want to make sure that the board understands what they're voting on. What the question is, did the appellant have a notice 30 days from the issuance of the building permit, which was November 27th, 2023? We have no evidence that my client received any sort of notice in the mail, any conversations with the building commissioner 30 days after that issuance, no notice of any sort of work that was happening on the property that would give him notice of a construction of this scale within 30 days after that date. If there was no notice within 30 days after that date, then we can proceed by seeking zoning enforcement whenever we want after that time period. That's what case law says.
Can we have the law department respond to that, please? I might disagree with that assessment, but I would like to have the law department try to give us their opinion on that.
In terms of the actual notice requirement?
On what council has said that the vote should be. I mean, I would suggest, I mean, that's just going to be me, but if I'm correct, that's fine, that we just take a simple vote whether or not this is timely and whether or not we have jurisdiction, and that's it. Not what council just said was No, it has to be that you'd find that there's no notice within 30 days, which again gets into the whole constructive notice issue with regards to all this.
Yeah, I mean-
And I don't want to belabor any of this. I don't want to get into the weeds with regards to this. I think it's a very simple vote from the board that it's simply, is this appeal timely and do we have jurisdiction? I think it's just simply, is this appeal timely?
Yes.
The jurisdiction thing would then just turn itself around, because then if it's not timely, we have no jurisdiction.
Yeah.
So that's pretty much it.
That interpretation would-
So I move that, we find that the appeal, I'll say it's not, since it's my motion.
Yeah, go
I'll
ahead.
make a motion to move that the appeal is not timely.
Okay.
And
Well,
we have
Mr. Chairman.
no jurisdiction.
Mr. Chairman,
So, yeah, go ahead, Mr. Brewer.
how do we judge the timing of this?
I think,
mean-
like we talked about, it's in the narrative that everyone shared this evening.
What?
It's in the communication that we
Well,
talked about.
explain it to me. Lay it out.
Okay, timeliness is this. And from my perspective, this is my opinion, the board, and again, this is my opinion, the board does not have to follow it. This is my understanding, is that timeliness, my issue of timeliness is this, that under the law, any decision of the building commissioner needs to be appealed that by an abutter or a person who is harmed or whatever the language is, needs to be appealed within 30 days of the issuance of the ruling, or once they got constructive notice. So if it's not appealed within 30 days, then they're out. There is the other caveat, which is what council's going on, which is just the determination of the zoning violation, which is what council's here, which with Mr. Caribbean's here for. That's another specific thing that notice is, what they're trying to say is doesn't start until they actually find out about it. So maybe I'm confusing the issues, but the bottom line is, my understanding of the law is that once a building commission makes its ruling, if it's not within 30 days, you're out. And that's it. That's and not getting into constructive notice and all that stuff, but that's my understanding. Council, go ahead, and I'm sure you're going to try to clarify what I'm trying to explain.
I think we're close. It's 30 days from when the building permit is issued. You have 30 days to appeal, but only if you have notice. If you don't have notice, there's no obligation to appeal within 30 days. So if you were to make a finding that it was untimely, you would have to prove that Mr. Caribbean didn't have notice of the building permit constructively or actually within 30 days of November 27th, 2023. If he didn't find out until February, then he can bring up this zoning enforcement and do this the other way, which is option B, seek zoning enforcement, and then appeal that determination. And that's what we did. So I know the law doesn't really make sense, but that's what the law is. If you don't have notice within 30 days, you don't have an obligation to appeal within 30 days. So if you were to make a finding, again, if you were to make a finding that it's untimely, you would have to show that Mr. Carabini had actual or constructive notice within 30 days of November 27th, 2023. There's no evidence.
Okay, thank you, sir, for your comments. Mr. Brier, are you all set with your question, sir, or do you need more clarity?
I'm sorry, Mr. Chairman, but I'm not.
Okay,
I'm
go
not.
ahead.
I'm sitting in here not even know what we're rendering judgment on. I mean, when you say we're going to the law department, I want the lawyers to tell us what the law is, and then we do that. It should be that simple. That's the way I see it. The other thing is, and I don't even know how pertinent it is, I don't want to start a big argument here, but I keep coming back to the original question I asked. What is the remedy that you seek? If somewhere along the line the city would have said, time out, we may have made an error here, then what would you have done? It's almost like, and I don't know you gentlemen, but it's almost like you say, Yeah, slap the commissioner just so we can prove he was right, he was wrong, we were wrong. I mean, this is kid stuff. You know what's going to happen here. The building's going to stay there. And 6 more families are going to occupy it, and that's a win for the city. Now, I'm not afraid to say that somebody made a mistake on behalf of the city, but I don't know if they did. And I don't know if I have purview to render judgment on that person. I think that what the building commissioner did, you're saying may be a violation, but I mean, there was certainly nothing nefarious here. So my question is, all right, so an error occurred. Tell us how you want to correct it. You're saying, well, we want to throw it all out the window, start all over again, and then what do you get out of it? If there were damages or something, I could see you fighting and pounding the table. But what do you get out of it? I mean, I don't want to see these things occur. I don't want to violate the law. I don't want to set precedent. I don't want to do any of those things. But tell me, dear sir, what do you get out of this? Pushing this issue, what are you getting?
Yeah, again, I think it's the zoning ordinance is written for a reason. It's there for a reason. And you need to go through the process. And again, they have to prove that they meet the criteria under the zoning ordinance to get a construction like this. This is a major, major project. And I know the town, the city might like this project, but there's a process they have to go through.
No, my colleague is right. I understand this is a question of process and not the building, but even the commissioner himself said that. All right, but I'm just trying to save a lot of time and aggravation. And if I don't know, maybe this is subject to further legal action, but I'm not voting to prolong this. That building's there. It's a benefit to the city. If an error occurred, you have my sincere apology as a member of the Zoning Board of Appeals. What that means, I have no idea. But I'm not voting to start this all over again, and as I said, just be like a dog chasing his tail. Come on, let's cut to the issue. You're not getting anything out of this. You live next door. You live next door, you got a beautiful property there. Now what? Nobody can tell me that. Tell me how you're damaged. You're damaged by saying, oh, the law wasn't upheld. Welcome to America. No further questions.
Thank you, Mr. Breer. Ms. Callen, did you have any comments, sir?
No, my motion,
yeah.
like my motion's on the floor.
Yeah.
I'm making a motion to find that the appeal is not timely and that we have no jurisdiction
All right,
to proceed.
perfect. All right, motion on the floor by Mr. Callahan. Do I hear a second?
Can you clarify that motion again? I just want to make sure I get it.
The motion is that the administrative appeal that's before us on 1280 Middlesex Street is not timely, and we have no jurisdiction to proceed. No, I made the motion,
Okay, so the motion
I'm
by
making a motion.
by Mr. Callahan.
so just looking for a second.
Yeah, we're looking for a second. All right, second by Mr. Prokop. Can we roll call, please?
Chairman Peck.
I'm voting to, it didn't meet the timely manner deadline, so,
Okay, so you're voting in favor of this motion?
yeah.
Okay. Chairman Peck, Member Callahan?
Appeal's not timely, so in favor of the
Oh,
motion.
yes. Member Briere?
Present. I have no evidence to judge that.
Okay.
So is that a yes or a no?
He's voting present.
I have no.
Oh, he's abstaining.
Abstaining, okay. Member Prokop?
Yes.
Member Hovey?
Deny.
Okay. Motion passes.
Okay. We don't
3,
need to
1,
proceed to-
1.
All right, motion passes. All right,
Because Member Peck, Member Callahan, and Member Prokop voted that, yes, it's not timely. You abstained, and Member Hovey voted no.
all right. All right, thank you folks for coming out this evening. right, moving on to the next item on the agenda, we have new business. ZBA-2024-489, and petition is a variance. The applicant is Alexa Furman, property located at 451 Broadway Street. The Lowell Zoning Board of Appeals will hold a public hearing to hear all interested persons relative to an application by Alexa Furman to open an event space at 451 Broadway Street. The property is located in the UMU zoning district and requires a special permit under Article 12.3G for the proposed use, variance under Section 6.1.43G for relief from off-street parking requirements and for any other relief required in the Lowell zoning ordinance. Anyone here for Broadway Street?
There's
Yes.
someone online.
Oh, good evening. You want to just tell us your name and address and tell us about your project?
Good evening. Yes, Alexa Furman, 451 Broadway Street. So the plan is, it is a two-floor building. So the upstairs is a beauty salon, and then downstairs, it's in hopes of a meeting room. So for any meetings, any family reunions, there is off-street parking, and as well there is street parking.
Okay, thank you. That's all you have for right now, ma'am?
Yes, for now, yes. Thank
Okay.
you.
All right, so we'll open up the hearing to the public. Anyone wishing to speak in opposition of this hearing? Opposition? Opposition? All right, hearing none, that portion of the public hearing is closed. Anyone wishing to speak in favor of this petition? In favor, hearing none. All right, the public hearing is closed. We're going to open questions and comments from the board. The chair recognizes Mr. Procope. Mr. Procope, the floor is yours, sir.
Thank you, Mr. Chairman. The applicant, I'm sorry, your name is Alexa?
Alexa Furman.
Alexa Furman. That property, you have two parking spaces in front, right? I notice. Is
There's three parking spaces.
and you need how many? It looks like you are looking for 14 off-street parking?
No, I'm not really looking for for the off-street parking. We have the three parking spots on the premises, and then there is also street parking available.
Okay. So you say downstairs would be a place for like an events room and the
Right.
capacity? And what's the capacity of that?
Yes, so it's for a meeting room. The capacity. Sorry, give me 1 second. I'm getting the square feet. So it's 30 by 20, the square feet. 50 feet. 30 by 20 feet.
30 by 20?
Capacity. Yeah, that's the square feet.
And so it says here you have a floor area ratio of a floor area of 2,700 square feet.
2,700 square feet.
Right.
Square feet, yes.
I don't know if you saw the comments here from the DPD that, the parking requirement for proposed use is one off-street parking per 200 square feet, which would require 14 off-street parking spaces.
Okay.
And
We're looking for also to purchase the across the street land, but there's no.
Yeah, there's also some land across the street that we were looking to purchase, to make parking. We just haven't been able to get in contact with the owners of the property.
Okay, so at this point, you don't have that availability. You only have the 3 parking spaces in front.
We have the 3 parking spaces and then also the street. I can't tell you how many spaces it is on the street, but there's also street parking.
Okay. Yeah, I think we may need some more information on here. I know the building department stated in this document that it seems like you have a limit of 49 persons in total, for capacity on there. And I'm just not sure if you may have the parking to support that, so.
Okay.
Yeah, I think let me segue into having some other opinions on here because I'm not sure. Thank you, Mr. Chairman.
Yeah,
Okay.
Mr. Prokop. Yeah, that makes sense. So, Mr. Prokop, so I'm just talking to you and I'm talking to anybody else. So they have 3 off-street parking spaces, but they need relief for 11. Yeah, so is that the question you have, like, they just don't have enough parking, essentially?
Yeah, because, yeah.
Yeah, I mean, it makes sense, the question.
That was my question / concern because it's 14, yeah.
Yeah, of course. So need relief for
they need
11?
11, yeah.
Okay. All right. Thank you, Mr. Prokop. The chair recognizes the Vice Chair, Mr. Callahan. The floor is yours, sir.
Thank you, through you, Mr. Chairman. Thank you, through you, Mr. Chairman. So, Ms. Furman, I'm trying to go through this a little bit, and you provided a deed that says the property is owned by Salon Solutions Realty LLC, but no indication on the application from the owner. What's your affiliation? What's your affiliation to the property?
Owner.
But are you it's the owner, it says the owner of the property is an LLC, and actually you just confirmed that on the Registry of Deeds website. So
Yeah, but we are the.
are you
owner.
are you the sole officer of the LLC?
Yes.
Yes.
Okay. Fran, is there any issues with that? It's really, she indicates in the application that she's the owner, but she's not. Then there's a second owner, and she's not either.
What? No.
Hold on, bear with me 1 second. I'm going through, we're talking to, I'm trying to get some clarification from our dedicated DPD staff. I don't know, is this application, because they really,
Well, with the LLC, you can't, if it says LLC, a human owns it somewhere.
well, the LLC is its own entity, though. Technically speaking.
Sure, okay. Well,
Because we have,
sometimes applicants,
we have in
applicant-
the application, just to note that she lists herself as the owner. She lists the second owner of Ariel Fermin. And then we have in the application, applicant if different from owner. Now, that should have been filled out, I guess, technically speaking, but because,
so you're saying that the owner line on the application is different from the owner that is listed?
of the property. The owner of the property is the LLC. And the LLC is a separate entity.
Sure.
So, I understand I'm putting my lawyer hat on. I understand that. I'm getting a little technical here, but I don't know if the application technically is really in full order. I guess we can discuss it, go further, whatever my other fellow board members think. I'll say with the condition that the applicant submit a new application indicating who the owner of the property is. Because the applicant should really be
The LLC?
well, the owner should be the LLC. The applicant should be whoever.
Sure.
So more of a Mr. Callahan, just more of a, you want a condition of like clerical, just updated clerical work?
If we go forward on this, I'll
Okay.
listen to everybody else.
Yeah, the applicant could provide, could submit
amended
an amended
application.
application form and supporting documentation showing that their relationship to the LLC,
Yeah. It just makes sense because,
Yep.
I don't know,
to clean it up and make sure that everything is in
not
order.
that I don't believe that she's not the owner. I
Yeah.
could certainly go on I'm trying to get on the Secretary of State's website to, check up the status of the LLC and make sure and see, I presume that she is. So she said she is, so.
That makes.
Okay. Well, I mean, with that, have you had a chance to review the, I'm sorry, to the applicant, Ms. Furman, have you had a chance to review the comments from the DPD?
Dile que out of the.
No, so the situation is why I'm also joining from here. I've been out of the country. My mother-in-law passed away, so I've been out of the country. So I didn't get a chance to view the comments.
Okay, so you haven't had a chance to review it. They did bring up a couple points, like one of the ones that they suggested we ask is how many customers you're anticipating will be appearing at the, no, how many customers you anticipate will be utilizing the, I guess, building for whatever, functions or whatever it is that you're proposing. Do you know?
So the capacity, yeah, just the capacity, the 49.
Yeah, that's what they're suggesting, that that the building department said that the capacity would be limited to 49. Is that, I mean, you understand that that's
Yes.
agreeable?
Yes.
Okay. And what are going to be the proposed hours of operation? Or is it based on whatever, I guess, whatever functions you get? Or do you, I mean, are the
Correct.
standard hours for operation, or?
Yeah, so it would be based on whatever whatever the plan is, whatever the customer needs.
Okay, so it's not like you're going to have someone stay, so no one's, so the operation is going to be there. Is anybody going to be present at the building to like greet customers, or is it just basically done online or done by phone, and then you have someone show up and let them in and they have their function?
No, we'll be there too. Yeah, I'll be there as well.
You will
Or
be there, okay.
I
So you
have,
an
we'll
office?
have somebody there.
You're going to have an office set up there?
Yes.
So I'm gonna have my full.
Okay.
So what I'm hoping to do is have the customer fill out an application with what their plan is, and then I'll review it and then go off of that, and then have somebody at the property, myself or my husband.
Okay. All right, I'll listen to my fellow board members what they would have to say, but if approved, I would make the condition that you have to file an amended application that notes that the owner of the property is actually the LLC, and that you are listed as the applicant. Okay?
Okay, so the other name that you see under that's my husband. So what needs to be done is the owner should be the LLC,
Yep.
and then the other lines will be myself and my husband.
Yeah,
that
well,
right?
on the application, when you filled it out, you put yourself as the owner, and then Ariel, that's your husband?
Right.
Yeah, you listed him as the second owner, but the property is actually owned by the LLC, which is a different
Okay.
entity, separate entity. So you have to list the LLC as the owner, and then you put yourself as the applicant. And you can put your husband somewhere too, if it doesn't matter. I've gone on the Secretary of State's website, I've confirmed you and your husband are the managers of the LLC. Just one of you on there is fine, as a representative for the LLC, so that's fine. But just want to make sure that the file is correct, and, we're dealing with the proper owner of the property, so.
Right. Okay, I understand.
Thank you.
Thank you.
All right, thank you, Ms. Callahan. All right, Chair, Mr.
Thank you.
Oh, sorry about that, my mic went off. But go ahead, Ms. Hubby, the floor is yours, sir, go ahead.
Thank you. I can appreciate trying to use this space. I think where my concerns are the lack of some sort of business plan. If we're going to have functions, are people going to bring in their own food and drink to these functions?
So the food, yes, they'll bring their own food. Drinks, that is what I'm hoping to offer.
Okay, so would you be applying for a license?
Correct, yes. That would be my
Okay.
next step.
So then we get into, we don't, if we don't have set hours, we could be approving something that's open till 12, 1 o'clock in the morning in a neighborhood with no off-street parking. So I think it's hard to make a decision with a lack of a business plan. You know, a function hall with no off-street parking, a meeting room, and the salon's still upstairs, so you're gonna have employees parking in the 3 dedicated spots, or they're gonna be taking up street parking too. I just think it's hard to render a decision not knowing what the plans are. The plans are pretty vague. There's a big opportunity for different things to happen. You know, they're going to bring their own food. They're going to bring, you're going to try to get a license to serve drinks there. I think we're getting into something that we don't really know what we're voting on at this point. You know, capacity up to 49. How are we going to track that? This is right next to an apartment building complex. So there's just a lot of unknowns. I think the economic development comment was a business plan. Personally, I would like a business plan to see what we have for standard hours operation, what days they're open, before I would be able to approve something like that. So that's all I have.
Mr. Hovey, I just want to clarify, sir. So you're asking this is part of a condition, or you're asking in terms of a continuance and come back kind of situation?
I would prefer a continuance. It's up to the applicant. I can't make an informed vote not knowing what we're approving, what type of business we're approving. I get what type of business we're approving, but to what scope of a business we're approving.
Okay. Thank you, Mr. Hovey. All right, Chair recognizes Mr. Breer. Mr. Breer, the floor is yours, sir.
I agree with the comments of my colleague, Mr. Hovey. And I think further information is needed with respect to a business plan to allow us to properly assess the actual usage of the site. Thank you.
Thank you, Mr. Breer. And then you already went, Mr. Prokop. Ms. Furman, I think what you're trying to do here is it's a nice creative idea of this building and this kind of lot. You know, I have similar questions to my colleagues, you know, like, you know, hours of operation, how do you plan on people, you know, if you're, for example, doing like a Sweet 16, so those, let's say 30 or 40 people come, are they, you know, where they're parking, do you have any, you know, parking agreements or lease agreements with any other abutting neighbors or properties? To me, I think this is a great idea, a great business plan. You know, to me, I think you just lack off-street parking, in my opinion, at least. You know, and I'm open to continue, like my colleagues say, but I'm also fine with going forward with a vote. So you heard the comments of the board. Ms. Furman, what do you want to do? Do you want to continue this so you can kind of update some documents, like my colleague said, in terms of the actual application, and then do more of a breakdown of a business plan, a narrative, a summary of what you plan to do and to mitigate any concerns and hours of operations, kind of like lay out all the steps? What do you want to do, Ms. Furman?
Yes, it's been a year when we bought this property, so we were trying to get in contact with the neighbor across the street because it's a empty land. And even my realtor sent letters to them and no answer. I was about to go to the city and try to find out who's the owner of the land because I would use it for parking too. But I also spoke to my neighbor that he has a gas station and, well, it's not operating as a gas station yet, but he has like a dealership, sort of like that. So sometimes he let me share the parking with him too. Like I spoke to him about this too, and he was willing to. So that's, you know, in like the hours, in terms of the hours, the salon like, we only work by appointments, with one customer at a time. And also, we only work until 5 from Tuesday through Saturday. So the events always, they start after 6 or 7, and regularly in Lowell, it's until 11. So I didn't see anything in the application where I should fill that out, the hours of operation or anything. So my mistake if I was supposed to give more details.
Oh, no, yeah, I mean, again, I think this is, to your point, ma'am, and my colleagues can chime in, I think this is kind of a learning process for most applicants that go through this process. Again, I think, so the comments of the board is they just don't have enough information. And so we can continue this so you can gather more information, all the questions we had, or your other option is to move forward with a vote. But again, just, it doesn't seem favorably at this point because not everyone has all the information. Again, just for my own input, what you're trying to do is, I think it's, you're trying to have parties, trying to make it the right way, and then make some money off the side. You're not doing some random house party with this 20, 30 cars and 20, 30 people come. You bought a business, you bought a lot, and you bought a building, trying to do it the right way. So I think it's a great business idea. It's just not a lot of detail into it yet. So this is why you're going through this process. So you don't do anything wrong. We're just trying to get all the information before we can have an informed decision, if that makes sense. So do you want to continue this, or you want to go with a vote?
I guess, to continue, right?
Yeah,
That
I think.
way-
Yeah, I mean that's your option. I think, in my opinion, I think continue this to get more information. Like my colleague said, all the questions we had answered, so it'll look more favorably, for your application, if that makes sense.
Okay.
All right.
Okay,
So
thank you.
you want to continue? All right. Ms. Sigliano, when's the next available opening on our agenda here? Is it anything on the 27th?
The 27th currently has 6 public hearings scheduled. So the board could choose to continue it to that date and push it to 7, or you could continue this matter to the February 10th meeting, which only has 3 items currently.
Ma'am, so the 27th is the next hearing, but it's pretty full. So how about we continue this to February 10th, and then so that way it gives you pretty much a good 3-4 weeks to get all the information, and then what I would like to see, at least from my colleagues and my perspective, I want to see kind of a layout of a parking plan, whether that's you have an agreement with the gas station or the owner across the street or whatever for 10 spots or whatever it is,
Oh, okay, thank you.
All right,
Okay,
so
yes.
you're okay with continuing the matter to February 10th, and then get all the information that we talked about tonight?
Sure.
Okay.
That includes updated, the amended application as well, listing the proper owner and her as an applicant, or her husband as applicant.
Did you get that, ma'am? This all the updated paperwork for the application initially?
Yes.
Yes.
Okay. All right. Any further comments by my colleagues?
Just,
Oh, go ahead.
yeah, quick one, Mr. Chairman. I know we're going under a special permit, 12.3G, commercial recreational facility indoor. It says that food and beverages that are to be served or consumed, the establishment must also conform to the applicable district and use requirements listed herein. So Fran, if you can give them guidance on whatever else information they need from that when they're, that would be helpful for us too, because to Member Hovey's point, it's an event center, but then they're going to try to proceed to get a liquor license, and then who knows where it goes from there. I mean, I don't, just kind of want to keep track of that, so.
Right. So it sounds like there are 3 things the board's looking for, and you can jump in if I'm missing anything, but a parking plan and any agreements related to parking, a business plan that elaborates on the details of the operation, including hours of operation, any plans for food and beverage. And then finally, an updated application form that corrects the owner, the line where the owner is included, and the applicant, so that the owner that is listed is the LLC and the applicant that is listed is Alexa Furman.
Yeah, or
or whoever?
Whichever one,
Yeah.
whichever one of the principals
Yeah.
wants to.
Sure.
It could be Alexa, that's fine.
Okay, and that was everything?
Yep.
Okay.
And that satisfies the needs of my colleagues? Okay. All right. Can we have a motion to continue the matter to February 10th, please?
Okay, to you, Mr. Chairman, regarding ZBA 2024-49 for petition for variance at 451 Broadway Street to be continued February 10th.
All right. Motion by Mr. Prokop to continue the matter.
Second.
Second by Mr. Hovey. Can we have a roll call, please?
Member Peck,
Approve continuance.
Member Callahan,
Approve continuance to February, whatever,
10th.
10th.
February 10th, 2025.
Member Briere, Member Procope,
Approve continuance of February 2025.
Member Hovey.
Approve.
All right. The matter's been continued. Ms. Furman, we'll see you February 10th, okay?
Thank you.
Okay, thank you very much. Have a great night.
You too. Have a good evening. And just for the public notice, there'll be no other public notice. This is the notice of the matter being continued. All right. Moving on to the next item on the agenda under new business, we have ZBA-2024-61. The petition type is a special permit. The applicant is Classical Signs, LLC, property located at 199 Plain Street. Classic Signs, LLC, seeking the zoning board approval to erect an eternally illuminated sign at 199 Plain Street. The subject property is located in the high-rise commercial HRC zoning district. The proposal requires special permit approval for section 6.3 for internally illuminated signage. Good evening, sir.
Good evening. This is Justin Parker from Classic Signs. That would be 13 Columbia Drive, Amherst, New Hampshire. We are proposing a set of internally illuminated channel letters that is going in place of the Sprint sign. We are seeking this permit because we could not verify the existing signage or the existing square footage. So we're just seeking a new special permit.
Okay. Thank you, sir. All right. If you have no further comments, we'll open up the hearing to the public. Anyone wishing to speak in opposition to this petition? In opposition? In opposition? Seeing none, that portion of the public hearing is closed. Anyone wishing to speak in favor of this petition? In favor? In favor? In favor? Seeing none, the public hearing is closed. We're going to open questions and comments to the board. The chair recognizes the vice chairman, Mr. Callahan. The floor is yours, sir.
Thank you, through Mr. Chairman. No real concerns about it. Seems straightforward. They just simply, no, Sprint hasn't been in existence in God knows how long. I used to have Sprint, so, and then it became T-Mobile, but so just simply changing whatever. So I'll be in approval. Thank you.
Thank you, Mr. Callahan. Chair recognizes Mr. Hovey. Mr. Hovey, the floor is yours, sir.
No questions.
Thank you, Mr. Hovey. Chair recognizes Mr. Briere. Mr. Briere, the floor is yours, sir.
No questions, Mr. Chairman.
Thank you, Mr. Briere. Chair recognizes Mr. Prokop. The floor is yours, sir.
No questions, Mr. Chairman.
Thank you. Again, like the vice said, makes sense. Is marketing. No concerns. All right. If there's no further comments, can we have a motion to approve the matter, please?
To you, Mr. Chairman, regarding ZBA 2024-61 for a special permit by Classic Signs for 199 Plain Street under section 6.3. A proposal requires a special permit approval under section 6.3 for an internal illuminated signage.
All right. Motion by Mr. Prokop, second by the vice chairman. Can we have a roll call, please?
Chairman Peck,
Approve.
Member Callahan,
Approved?
Member Briere,
Approval.
Member Procope,
Approve.
Member Hovey.
Approve.
All right. You've been approved. Thank you for coming out this evening.
Thank you very much. Have a good
Thank
one.
you. Have a good evening, sir. All right. The next item on the agenda, we have ZBA-2024-65. Petition is a variance. The applicant is Kojak Development Corporation. Property located at 257 Aiken Ave. The Lowell Zoning Board of Appeals will hold a public hearing to hear all interested persons relative to an application by Kojak Development Corporation to construct a single-family home on the currently vacant lot at 257 Aiken Ave. The project would separate the lots at 257 and 261 Aiken Ave, which were previously held in common ownership and considered merged for the sake of zoning. The subject property are located in the traditional neighborhood single-family TSF zoning district. The proposal The proposed new single-family home at 257 Aiken Ave requires variance approval per section 5.1 for relief from the minimum lot size, minimum frontage, and minimum lot area per dwelling unit requirements and any of the required in the Lowell zoning ordinance. Good evening, Counselor.
Good evening, Attorney George Theodoro, 491 Dutton Street, Lowell, the attorney for Kolchak Development. And with me here tonight is Matt Hamber of Lamplex, as well as Dean Jenkins, who is a contractor for Kolchak Development. You have before you our application for a variances for two parcels, as you said, for 257 Aiken Avenue and 261 Aiken Avenue. Those two parcels are held in common ownership. They are both have their own independent historical legal description and comprised 6,000 square feet with frontage of 50 feet in the traditional single-family zoning district, which requires under the 5.1 of the zoning ordinance 7,000 square feet for a single-family home and frontage of 70 feet. So we have before you the application for variances to construct the new home at 257 Aiken Avenue, which will be an approximately 1,750 square foot single-family home with the appropriate parking that meets the zoning, driveway along the side of the house. It will have 3 bedrooms with a porch in the back, exiting also from the basement with the bulkhead. And we have we requested requirements for the relief of the minimum lot size and the frontage requirements, as well as the application of the existing two-family home at 261 Aiken Avenue, which sits on the exact size lot as the adjoining parcel, being 6,000 square feet, and both of them have frontage of 50 feet, which requires variances for both of them. You have in front of you the comments by the Department of Planning and Development, which indicated that these lots are similar to other lots in the neighborhood. And I just want to point out that the existing two-family was built in 1920. You have a handout that was given to you, which is a lot analysis, in which it has in all the lots which are coded in green on this plan, shows you all the lots in the area that are of 6,000 square feet or less. So these are all the lots in this specific area, both on Aiken Avenue, adjoining on Billings Street, By Street, and Hildreth Street, that all have less than 6,000 square feet, and that have at least 50 feet of frontage or less. So by virtue of this, the historical example that we're showing you of the existing lots in the area, that these variances can be passed without changing the character and style of the neighborhood and without derogating the intent of the zoning ordinance. And if you go by this street, you take a look at this street, there's a number of different style homes that have been built there, but the majority have been built from 1920. Some of them are more modern. There's a couple of homes there that are more modern, and we believe that in placing this home on the lot that it'll fit in well in the neighborhood. We comply with all the requirements for stormwater management, where all the stormwater is going to be maintained and kept on site. We have the improvements that are made with with 2 shade trees in the front to add that to the neighborhood. And as we stated, as was stated in the comments from the Department of Planning and Development, we believe that this can be approved and be a good addition to the neighborhood, providing another family with home ownership, providing tax revenue to the city, and being an improvement overall in the neighborhood by adding a fine quality single family house. If you have Any engineering questions at all, or questions with respect to the site? We did talk to a couple of the abutters earlier and spoke to them about the project. And we look for your approval tonight. And thank you.
Thank you, Councilor, for the narrative and comments. We have nothing further. We'll open the hearing to the public. Anyone wishing to speak in opposition of this petition? In opposition, in opposition. Seeing none, that portion of the public hearing is closed. Anyone wishing to speak in favor of this petition? In favor, in favor. Seeing none, the public hearing is closed. We're going to open questions and comments from the board now. The chair recognizes Mr. Hovey. Mr. Hovey, the floor is yours, sir.
Thank you. I think this fits in with the neighborhood. I looked at, provided lot sizes. There's a lot at that, 6,000 or less square feet. I think most of the ask on this is for the existing property. There's really not much we can do. It's 3 feet next to a property line. We're not going to make you move a house, right? It's too tall. We're not going to. So I think you did a good job with the plan, especially with the new house, because there's really not much you're asking. You're asking for frontage and lot area. I don't have much to say. I think we had so much information provided on this through you folks, and in my opinion, it's kind of a no-brainer. So I will be voting in favor of this.
Thank you, Mr. Hovey. The chair recognizes Mr. Briere. Mr. Briere, the floor is yours, sir.
Thank you, Mr. Chairman. This will be a great fit, a great addition to the neighborhood, and I'll be voting in favor.
Thank you, Mr. Briere. The chair recognizes Mr. Prokop. Mr. Prokop, the floor is yours, sir.
Yeah, thank you, Mr. Chairman. Being very familiar with this neighborhood and the empty parcel of land, I think it would be a great addition, to the character of the neighborhood. I also think that it seems like a lot of care went into the presentation and the development of the plans that I don't see how there's any detriment to this. So I would be voting in favor as well. Thank you, Mr. Chairman.
Thank you, Mr. Prokop. The chair recognizes the vice chairman, Mr. Callahan. The floor is yours, sir.
Thank you, through Mr. Chairman. I agree with my fellow board members, and this will certainly fit within the neighborhood. But the one thing I did notice, Council, the plans for the new building on 257, we got the height at 33.6 inches. Why can't we meet zoning? If the zoning's 32, why can't we meet zoning on that?
We can.
Okay. All right. I just noticed that, so I just figured, I figured just kind of, because the existing home is the same height. I can understand it being, trying to keep them in conformity, but I really would like to it's only a foot and a half.
Foot and a half, yeah, 32.
Really should try to just make it within zoning on that. So if you just update the plan, just update the specs and make sure that that's taken care of. But other than that, yes, I think this will certainly fit in with the neighborhood, and I wish you the best of luck. Thank you.
Thank you, Mr. Callahan. Did you want that as a condition, sir, or just?
Yes, please. Let's
Okay.
condition with the updated,
Okay.
updated rendering showing that the height of the new house to be located on 257
Okay.
to be 32 feet.
Okay.
Thank you.
Thank you. Again, to my colleague's point, I think this is a great addition. We need more housing. It's a single, it's a vacant lot, so I think a single family fits in well there. So thank you again for your investment to Kojak. I know they do a lot of properties in the city, so thank you for that. So we only have one condition about the height, the updated plans for the height to 32 feet, and you're amenable to that, right, Councilor?
Yes, we
Okay.
are.
Okay. All right, any other comments from my colleagues before we move forward with a vote, a motion? Seeing none, can I have a motion on the matter?
To you, Mr. Chairman, regarding ZBA 2024-65 for variance at 257 Aiken Ave, Subject property for variance approval under section 5.1 for relief from minimum lot size with the condition of an updated site plan rendering showing 32 feet.
For the height, perfect. All right, motion by Mr. Prokop,
Second.
second by the Vice Chairman. Can we have a roll call, please?
Chairman Peck,
Approve the condition.
Member Callahan,
Approve a condition.
Member Briere, Member Prokop,
Approve with conditions.
Member Hovey.
Approve.
All right, you've been approved. Wish you best of luck.
Thank you very much.
Thank you again for coming out this evening. We didn't even need that, Mr. Hanlon. All right, moving on to other business on the agenda. We have minutes for approval for December 9th, 2024. To my colleagues, do we have any edits, comments, additions to the minutes? All right, seeing none, can I have a motion to approve the minutes, please?
To you, Mr. Chairman, approve minutes, minutes for approval for December 9, 2024.
Second.
All right, motion by Mr. Prokop, seconded by
Hovey.
Mr. Hovey. All in favor of approving the minutes, say aye.
Aye.
Aye. The ayes are unanimous.
For the record, Mr. Chairman, I was
Yes.
not present at the meeting, so I'll abstain.
Oh, excuse me. So 4 for ayes and 1 for abstain for the minutes for approval. All right, any other comments or questions before we adjourn tonight? All right, seeing none, can I have a motion to adjourn, please?
To you, Mr. Chairman, motion to approve. A motion to adjourn.
All right, motion by Mr. Prokop to adjourn,
Second.
seconded by the Vice Chair, Mr. Callahan. All in favor, say aye.
Aye.
Aye. Ayes are unanimous. There was no nays. We are adjourned. Thank you. Have a good night, folks.